We have successfully navigated the first three essential elements of a negligence claim: duty, breach, and causation. Now, we arrive at the final required component necessary for the plaintiff to prevail: damages. It is crucial to understand that even if a defendant owed a duty, breached that duty, and that breach factually and proximately caused an event, the plaintiff still cannot recover unless they can prove they suffered actual, legally recognized harm. If the defendant's careless actions cause nothing more than a fright or a near miss, the claim fails right here. Damages represent the monetary compensation sought by the injured party to make them whole again for the losses they sustained due to the defendant's tortious conduct. This element shifts our focus entirely from proving fault to quantifying the resulting injury before we move on to examining potential defenses that might reduce or eliminate that recovery. Having established that legally recognized harm must exist, we now turn to quantifying that harm. In tort law, damages are broadly categorized into two primary types based on their objective. The first, and most common, category is compensatory damages. The entire purpose here is to compensate the plaintiff, to make them whole again by covering their actual losses, whether those losses are easily quantifiable economic costs or subjective, non-economic suffering. The second category is punitive damages. These are fundamentally different. They are not designed to compensate the victim, but rather to punish the defendant for particularly egregious behavior and to deter similar conduct by others in the future. It is vital to remember that in typical, standard negligence cases involving simple carelessness, punitive damages are almost never awarded. They are reserved for conduct that rises far above mere breach of duty, making the distinction between these two types crucial for understanding recovery potential. Now that we have isolated compensatory damages as the mechanism to make the plaintiff whole, we must examine their internal structure. Compensatory damages are universally divided into two distinct components: special damages and general damages. Special damages cover the economic losses, the actual, out-of-pocket costs that are easily quantifiable and verifiable, often supported by receipts or payroll records. Think of past medical expenses, future medical care projections, and lost wages from time missed at work. These are objective calculations. In contrast, general damages address the non-economic, subjective losses. These are much harder to assign a precise dollar value to because they relate to the plaintiff's personal experience. Key examples include pain and suffering endured due to the injury, and emotional distress or mental anguish resulting from the incident. While special damages are concrete figures, general damages require the jury to assess the intangible impact of the defendant's negligence on the plaintiff's quality of life. We have thoroughly covered compensatory damages, designed solely to reimburse the plaintiff for their losses. However, tort law recognizes a second, much rarer category: punitive damages. These are not intended to compensate the injured party but rather to punish the defendant for truly egregious behavior and deter similar conduct across society. Because of this punitive nature, the threshold for awarding them is significantly higher than for mere negligence. The defendant's conduct must rise to the level of being malicious, willful, wanton, or demonstrating a reckless disregard that goes far beyond simple carelessness. Crucially, these awards are subject to constitutional scrutiny under the Due Process Clause. The Supreme Court has provided guidance suggesting that punitive damage awards should generally be tethered to a single-digit multiplier of the underlying compensatory damages awarded. Exceeding this ratio often raises serious constitutional concerns regarding excessive fines. Having established the potential recovery for the plaintiff, including the rare possibility of punitive awards, we now turn our attention to the defendant's primary avenues for counterargument. These are not challenges to the plaintiff's initial proof of duty, breach, or causation. but rather affirmative defenses rooted in the plaintiff's own conduct. The law recognizes that sometimes, the injured party shares responsibility for their own harm. This concept fundamentally shifts how we view liability. We move from asking solely, did the defendant breach their duty, to asking, to what extent did the plaintiff's own negligence contribute to the resulting damages? Depending on the jurisdiction and the specific defense asserted, the plaintiff's fault can result in a complete denial of recovery, or it can lead to a reduction in the final monetary award. We are about to explore the two major historical and modern approaches to handling this shared responsibility: contributory negligence and comparative negligence. We begin our exploration with the original common law approach to shared fault, contributory negligence. This doctrine represents the strictest possible standard for plaintiffs seeking recovery. Under contributory negligence, if the evidence shows that the plaintiff's own negligence contributed in any measurable way to their injuries, even if that contribution was only 1%, the plaintiff recovers absolutely nothing. The entire claim is barred. This is the ultimate all-or-nothing rule based entirely on the plaintiff's conduct. Because of its severe and often unjust results, this rule has been abandoned by the vast majority of jurisdictions. However, understanding contributory negligence is crucial because it serves as the historical baseline against which all modern comparative fault systems are measured. A small minority of states still adhere to this harsh standard, making it essential knowledge for the bar exam. The previous chapter established the harshness of contributory negligence, where any fault barred recovery. Now, we pivot to the modern approach adopted by most jurisdictions specifically to address that unfairness: comparative negligence. This system fundamentally shifts the focus from total bar to proportional responsibility. The core principle here is simple: damages are no longer an all-or-nothing proposition. Instead, the jury assigns a percentage of fault to every party involved, including the plaintiff. The plaintiff's total recoverable damages are then reduced by their assigned percentage of fault. For example, if the plaintiff suffered $100,000 in damages but was found 20% at fault, they recover $80,000. This system ensures that recovery is directly proportional to the defendant's share of the blame, making it the prevailing standard across the United States today. We now examine the two main flavors of comparative negligence, starting with the most plaintiff-friendly approach: pure comparative negligence. Under the pure system, the plaintiff can recover damages even if they are overwhelmingly at fault. There is absolutely no threshold that bars recovery based on the plaintiff's degree of fault. The plaintiff's total damages are simply reduced by their assigned percentage of responsibility, no matter how high that percentage is. For instance, if a jury determines the plaintiff was 99% responsible for their own injuries, they still recover 1% of their total damages. This contrasts sharply with the older contributory rule. To illustrate with a concrete example, suppose the plaintiff sustained $100,000 in losses. If the jury assigns 80% of the fault to the plaintiff's recovery is reduced by 80%, resulting in a final award of $20,000. This pure system prioritizes compensation over punishing the plaintiff for minor fault. Moving beyond the pure system, we now address the second, and arguably most common, approach: modified comparative negligence. This system seeks a middle ground by imposing a specific threshold on the plaintiff's fault. If the plaintiff's assigned percentage of responsibility crosses this threshold, recovery is completely barred, unlike the pure system. There are two primary ways jurisdictions implement this threshold. First, the not greater than rule. Under this variant, the plaintiff cannot recover if their fault is 50% or greater. If the jury finds the plaintiff exactly 50% at fault, they recover nothing. Second, the not as great as rule. This is slightly more generous to the plaintiff, barring recovery only if the plaintiff's fault is greater than 50%, meaning 51% or more. Therefore, if the plaintiff is exactly 50% at fault, they can still recover under this rule. Understanding this precise difference between 50% and 51% is vital, as many states adopt one of these two modified standards. We have now completed the full analysis of negligence. Remember, after successfully proving duty, breach, and causation, the plaintiff must clear the final hurdle, proving legally recognized damages. Once damages are established, the focus shifts entirely to the defendant's affirmative defenses, specifically concerning the plaintiff's own conduct. The landscape here has dramatically evolved. We moved away from the unforgiving, strict contributory negligence rule, where any fault barred recovery. Today, the vast majority of jurisdictions employ the flexible, proportional allocation system found in comparative negligence. Whether pure or modified, this modern approach ensures that recovery is generally reduced, but rarely eliminated entirely, based on the plaintiff's percentage of fault. This concludes our comprehensive study of negligence. Next, we will pivot to a different foundation of tort liability, strict liability.